That will be the functions of the expert. Yeah. And then kita ada whatever it is, the court is the final arbiter. Yeah, yang decision making whether to follow which opinion, it will be the court yang decide. And the court must not ignore the evidence or the opinion of the experts prior to giving its decision. Maknanya kalau you ada lebih daripada satu pakar, court kena consider ke semua opinion of the pakar, lepas tu decide yang mana yang dia nak ikut. Okay? That will be the judge's duty. Kita pun discuss yang ini kan last week, di mana ambil contoh kes Anwar Ibrahim ke, yang with regards to evidence in support, sama ada dia produce sendiri dia punya evidence in support ataupun dia refer kepada evidence yang dah diproduce oleh the earlier expert tapi bagi opinion yang inconsistent, maknanya contradicting. Yes, that will be section 46. Okay, itu yang kita dah discuss last week. Betul? Did we stop there, right?
Betul, madam.
Okay. So today I just wrap it off a little bit untuk expert opinion. So itu sebenarnya yang because you all punya subject matter ni is more dealing with expert opinion. So saya fokus more on expert opinion. Saya tak adalah fokus sangat on the non-expert. But nevertheless, kalau kita lihat pada section 47, 48, 49 and 50, this provision talk about non-expert opinion. So section 47 refer to non-expert opinion, di mana we talk about handwriting punya evidence. So when we talk about handwriting punya evidence, so kita kata kalau ada handwriting, okay, to determine whether the handwriting is actually genuine or not, kita boleh bawa pakar di bawah section 45, right? Iaitu kita bawa pakar ataupun kita bawa di bawah section 47. Dan jika kita bawa dia di bawah section 47, sekejap ya. Jika kita bawa evidence dia di bawah section 47, dia adalah non-expert. Right? Dia adalah non-expert. So if you look at this situation, ya, kalau you buka section 47 tu, you are referring to someone yang familiar ataupun acquainted with the document. Contohnya kalau you adalah boss, you punya PA. So you punya PA is acquainted with your handwriting. So dia boleh testify in the court sebagai seorang yang dah biasa tengok you punya handwriting. So dia akan bagi keterangan bahawa ya, inilah handwriting saya punya boss. Katakanlah that is the issue. So satu, you panggil pakar akan gunakan teknik-teknik dia lah ya. Sama ada dia buat comparison ke, dia punya slanted dia, okay, tajam dekat sini tekan apa, dia punya ink kat sini tekan ke whatever lah. Right, that depends on the pakar. Tapi dalam 47, you are talking about non-expert but someone who is acquainted with the document. So macam mana dia acquainted with the document? Ya, iaitu macam mana dia acquainted tu maknanya dapat tahu ya pasal dokumen tu, sama ada dia nampak. If you look at this one, the witness sees the person write. Maknanya macam PA nampak bos dia tulis. Kan? Ataupun witness receive the document written by the person. Dia terima dokumen yang diterima daripada orang tu, lepas tu okay, this is a document habitually submitted to the witness in the course of ordinary business. So that will be the situation where it is not expert. So this is a non-expert opinion. Subject matter dia adalah handwriting. So if you have forgery case ataupun if you have will, ya, will punya case, katakanlah ada orang claim that will itu, wasiat tu bukan ditulis olehnya, then you are talking about the genuineness of the handwriting. Okay, this will be the way for you to reflect, ya. Okay, now section 47. Section 47 is actually relating to general opinion, relating to general custom and right. So you're talking about general customs and right here. Okay, so it's not applicable to private customs and right. Apa benda ni? this is a situation where we talk about custom ya, ataupun adat yang umum. Contohnya, dekat Negeri Sembilan dia ada banyak adat kan, dia ada macam-macam undang lah apa ke semua kan. So in Negeri Sembilan, so what happened here is that relating to one particular adat, so that is the adat that is practiced by the community, general community dekat area tu. Ya, katakanlah dia ada banyak undang-undang dia lah kan. And then what you have here is that this particular person ada dispute relating to one subject matter. This particular person is giving opinion relating to the adat. So it's a general custom. Now this will be compared to private custom and rights. Now what does it mean by private custom and rights? Now private customs and right, kat sini, dia merujuk kepada keadaan, katakanlah kita ni, alright, keluarga kita ni very close. We have a very big family. Okay, we have very big family, ataupun kita ambil macam keluarga Mak Kilau lah kononnya. Ya, ambil keluarga Mak Kilau. So keluarga Mak Kilau dia ada banyak generasi. Katakanlah, kadang-kadang kita dalam satu keluarga kita, kita ada adat yang kita practice dalam kita punya own family member. So you are talking about here private custom, private rights. So maksudnya di kalangan adik-beradik ini kita punya practice. We accept it as kita punya budaya dalam kita punya keluarga kita. So dalam konteks itu, you tak boleh beri keterangan relating to apa yang dipraktiskan oleh budaya ataupun family tersebut. Because it is not regarded as public rights, ya, ataupun public or general custom. So kalaulah saya punya, okay, saya adik-beradik saya ada 12. So saya generasi atuk nenek saya campur dengan adik-beradik saya, lepas tu anak-anak saudara semua, cucu-cucu semua, katakanlah kita ada 200 family member. So masing-masing memang daripada dulu sampai sekarang practice one particular budaya. So ada dispute relating to this practice, right? I tak boleh nak panggil orang luar because it got nothing to do with them. Ya, sebab itu bukanlah opinion of non-expert opinion, sebab dia tak related. Tapi kalau macam Abi tahu tadi, budaya dekat Negeri Sembilan. So everyone ataupun satu tribe, kaum, suku dekat Banjaran ke kat mana ke kan. So you are talking about the general budaya, the general adat practiced by that particular community. Dan you boleh panggil dia. So ada orang tua yang umur 100 tahun yang boleh bagi opinion what is actually the adat practice, okay? So that will be the position under section 48. Section 49 talk about opinion as to the usage and tenets. Now, usage and tenets refer to what the people are now recently in the habit of doing. So maksudnya, ini merupakan sesuatu budaya yang baru muncul. Right? So budaya kita daripada dulu masa kita muda, masa kita kecil, budaya dia lain, sekarang dia budaya dia lain. So budaya main teng-teng dulu zaman kita kecil. Sekarang budaya main game. Computer game. So you are talking about the change of budaya dalam satu community. Benda yang baru ya, that the people now in the habit of doing. So sekarang semuanya communication kita dah tak ada dah kat raya, betul tak? Kalau dulu kat raya pecah kaca, pecah gelas, apa benda semualah. Kalau ingat dah kat raya, lepas tu kita gantung-gantung dekat rumah. Kita dapat macam gitu. Pecah kaca, pecah gelas, terima harap balas ke whatever semua kan. Dah sekarang dah semua main WhatsApp je. Jemputan kahwin pun WhatsApp semua. So there's a change in the budaya. So if you have that kind of situation, so kata bahawa perubahan budaya tu, someone from the general public that relates to the matter can give opinion of that. Yeah, so that is the situation under section 49. So dia more kepada perubahan budaya yang benda yang baru. Yeah, okay. So if you look at the case of Lee Yi Tiong tu, so this is a situation where you are talking about the methods of gambling. So ini benda tu special. Maknanya okay, gambling dulu daripada sistem yang dulu sampai sekarang dia berbeza. Ya. Teknologi change, lepas tu sistem tu pun berubah. So maknanya orang yang acquainted with that will give evidence. Tapi dia adalah bukan expert, dia bukan pakar. Tapi because of dia punya, mungkin dalam kes ini dia venture into the area. Dia banyak buat siasatan dalam kes tersebut, so dia bagi keterangan, dan keterangan ni bawah section 49. Get that? Okay? Sebab kadang-kadang bila kita tengok sesuatu dekat dalam online tu, kita tak tahu benda tu ada gambling. Ya? I tengok benda tu mungkin biasa-biasa je. Tapi kalau detektif polis yang biasa dengan area tu, dia tengok benda tu, dia tahu orang ni sebenarnya tengah berjudi. So that is the position. Okay? So itu section 45, non-expert. Okay? Now, section 50 is referring to opinion on relationship. So opinion on relationship pun, okay, contohnya I nampak A and B. Lepas tu ada anak kecil, C. Dia orang tak kahwin. Right? So, tapi I nampak every day dia pergi ke mana sana sini. So, I may give an opinion relating to that particular relationship. I nampak. But I am giving a non-expert opinion. I tak check dia punya DNA dia anak dia ke tak. I tak check dia orang married ke tak. Alright? So, you are talking about this kind of situation. Yeah? So this is opinion of relationship lah. Contohnya kita ada dalam contoh case tu, you ada defamation case, you kata bahawa A here is actually having a mistress, katakanlah A ni ada mistress, sebab apa you sentiasa selalu nampak dia pergi dekat kondominium tu, dekat dalam kondominium tu he will spend the night, lepas tu kat situ ada satu child umur 2 tahun and a woman. You know he's not married. Okay, katakan. So you, maybe neighbor dia, can give opinion relating to what you perceive. Iaitu mungkin, okay, A went into the condo, lepas tu dia selalu pergi holiday dengan this particular woman, nampaklah dia pergi balik, pergi berkelah ke whatever, you nampak dia bawa barang and all that. So you can give opinion relating to possible relationship. That is situation number section, bawah section 50. Get that? So section 47, 48, 49, 50 ni semua adalah non-expert opinion. Now, okay, you all ada, I rasa ingat dulu dalam grup ni ada yang involved dalam deviant practice kan? So deviant practice maksudnya katakanlah macam kumpulan-kumpulan agama yang regarded to be deviant, ajaran sesat and what not. Katakanlah you nak prove whether this particular this particular kumpulan is ajaran sesat ke tidak, you nak panggil seseorang bagi keterangan, mungkin di bawah section 48. Tapi orang tu kena ada some kind of knowledge in that area. Okay? Untuk dia beri keterangan. So that will be the position on opinion evidence. Get that? So opinion evidence ada dua, satu expert opinion, satu lagi non-expert opinion. Non-expert opinion not so much of an issue, right? I rasa lah dalam case, dalam konteks you all punya practice lah ya. Tapi kebanyakannya mungkin deal dengan expert opinion. Okay, with this I conclude tajuk kita, topik yang pertama opinion evidence. Boleh? Ada soalan ke tidak on opinion evidence? Ada ya? Okay, by the way, kita punya apa namanya, okay, I akan miss kelas dengan you satu hari election, betul? Nah, 19 bulan.
Betul.
I akan miss kelas ya, satu lagi election, satu lagi adalah pada 3 hari bulan. 3 hari bulan Disember saya tak ada dekat Malaysia ya, saya akan present paper dekat ke Indonesia, so I will not be around. So 2 hari tu, jadi you all decide lah nak buat kelas tambah, nak buat kelas ganti ke tak nak buat kelas ke, is up to you. Kalau korang kan sosok kuku ala-ala je, ikut korang lah, rasa cukup ke tak cukup ke ya. Saya boleh habiskan syllabus, tapi saya takut tak ada sempat nak kita buat discussion. Okay, tapi kalau saya buat tu nanti laju sikit lah sebab dia sebenarnya sama ada saya laju ke cepat ke kelas tersebut, dia bergantung pada you all. Kalau you all ni, okay, banyak tanya, two-way communication, maka lambatlah sikit, taruhlah sikit explanation. Okay? Kalau you all dengar je, lepas tu tak tahu ke mana, dia akan jadi cepatlah discussion tu. Betul tak? So, lepas tu nanti macam tak faham lah. Okay? Tapi yang penting ialah, sebenarnya faktor determination sama ada dia jadi lama ke, cepat ke, mostly will be on you. Okay? Sebab saya akan ikut pace saya je, ya. Yang saya akan stop whenever you ask me questions. Okay? Alright. So this will be the end of our first topic. Then kita akan move on to our second topic, ya. By the way, you punya assessment yang pertama lepas cuti kan? Lepas saya buat tutorial, I nak buat tutorial dengan you all dulu, ya. Tapi kita do the second topic. Okay, topik kedua ni agak complicated sikit lah. You ada lecture notes dia. Topik kita character evidence. Alright. So, sekarang pukul 8.54. I nak kasih ada breathing space sebelum kita masuk ke topik baru. I bagi you 5 minute break sekejap. Okay, sebelum kita masuk on character evidence. Okay.
Thank you, Doktor.
Okay.
Thank you, Doktor.
21 I ambil attendance. I download attendance. Okay, can we start?
Okay.
All right. Okay, so we are looking at a new topic. Semua ada kat sini harap-harapnya ya. Okay. Topik baru kita on character evidence is slightly tougher than opinion evidence sebab dia lebih technical. And of course, I will focus on character evidence in criminal proceeding. Tetapi I will just mention to you the position of character evidence in civil case, yeah. Now, what will be the content of our discussion on character evidence? Yeah. Number satu, kita akan discuss what is actually character evidence. Yeah. Apa yang dimaksudkan dengan character evidence? Very briefly, we will discuss character evidence in civil cases. Then we are going to focus more on character evidence in criminal proceedings. And then we're going to look at character evidence under other provisions of the Evidence Act. Okay, this will be our focus. Now, what do you understand by character? Yang korang faham pasal character apa? Yeah. Now, when we talk about character tu bahasa Melayu apa? Ya kalau dalam tak tahu ya kalau
Perwatakan.
Perwatakan. Okay. Maknanya keterangan watak. Ya, watak. So, apa yang dimasukkan dengan character evidence? Okay, character evidence is actually, kalau you tengok ya general rule dekat sini, character evidence are generally not relevant, not admissible to be produced in the court. Yang ini relate kepada criminal case, ya. This is actually in criminal case. Right? So, in criminal case, as a general rule, watak seseorang tu tidak relevan untuk dibawa ke mahkamah. Okay? Dan bila kita cakap pasal watak tu general rule, right, when you talk about character evidence, there are a few things that you got to consider. Okay? The case of R.N. Whitmore here is referring to bad character evidence. Now, when you deal with character evidence, there are a few things that you have to bear in mind. Kita kena faham apa itu character. Right? Number dua, kita kena faham. So, satu, of course, we should know what is character. And number two, kita tengah deal dengan civil ke criminal case. Ya, kita kena deal dengan civil ke criminal case. Number three, adakah kita tengah deal dengan good character evidence ke ataupun bad character evidence? Okay? Dan number empat, kita tengah deal dengan whose character? Karakter siapa yang kita tengah discuss? Karakter accused person ke? Karakter saksi ke? Karakter victim ke? Okay? Lepas tu, kita akan tengok number 5 will be what? Will be the effect in producing character evidence. Now, as a general rule, character evidence is not relevant, not admissible. Sebab it is not the duty of the court to basically try a case. Okay, it is the duty of the court to try a case. Maknanya, seseorang yang berperwatakan kurang baik, tak semestinya commit a crime. That's the idea. Yeah. You seorang yang pemarah. You tak commit murder. Yeah. You may be kedekut. Tu watak tu semua kedekut tu. Yeah. You may be kedekut tapi you tak pukul orang. So that's the idea, right? So perwatakan seorang itu tidak relevant, not admissible. Now, apakah yang dimaksudkan dengan watak seseorang ya? Character evidence. Now, when you look at character evidence, let's look at section 55. Section 55. Tengok section 55. Okay, let's read section 55. So, boleh baca seorang. Section 55. Kan kalau saya seorang je yang cakap kan susah tak?
Boleh doktor?
Boleh baca.
Okay, character as affecting damages in civil case. Damages. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Kemudian ya.
Explanation?
Okay, in section 53, 52, 54, and 55, the word character include both reputation and disposition. But, except as provided in section 54, evidence may be given only of general reputation and general disposition, and not of particular act by which reputation or disposition is shown. Yes.
Okay. So that is section 54. Now, if you look at section 54 here, you will find that, okay, the main provision of section 54 tu cakap pasal character evidence dalam civil case. Okay? Tetapi I nak tengok bila kita cakap pasal definition of character evidence, we look at explanation. Maknanya dalam section ini, explanation yang cakap character evidence includes disposition and reputation. So ada dua. Right? So when we talk about character evidence, mak ai tebalnya ke tak ni ya. Character evidence ada satu reputation, satu lagi disposition. Macam mana nak menghaluskan tulisan je ha? All point. Tak nak. Tiba-tiba besar lah pula ai. Okay. Tak reti. Okay. So kita ada reputation and disposition. So reputation refer to apa? Reputation is actually referring to what the people perceive of you. Now, we faham ya, dalam konteks the meaning of character evidence di Malaysia, kita ada dua-dua reputation and disposition. Tapi dalam common law, yang maksud English punya provision, cuma satu sahaja, iaitu reputation sahaja yang reflect kepada character of the person dalam common law punya business, ya, dalam common law punya approach, ya. So maksudnya dekat Malaysia, kita apply kita punya law dan section 55 explanation to explain reputation ada dua benda, iaitu character evidence to mean reputation and disposition. Now, what is reputation? Reputation is referring to what people perceive of you. Maknanya you are talking about the general public. Yeah? You're talking about the general public perceives of you. So, kalau I mention Siti Nurhaliza, what do you think is her general reputation?
Top singer.
Okay, she's a top singer. Reputation lagi?
Kahwin Dato' K.
Kahwin dengan Dato' K itu bukan reputation. Come on, reputation. What people perceive of Siti Nurhaliza? Selain daripada suara dia sedap ke apa ke? Okay.
Baik, sopan santun.
Okay, seorang yang very well mannered, sopan santun. Seorang yang very dignified person, tak involved dalam gossip. So maknanya dia seorang yang pandai jaga diri, right? So that is people perceives of her, right? That is general, that is reputation. So kalau I mention pelakon yang baru ni kena denda,
Zul Arifin.
Okay. Kalau I mention Zul Arifin, what do you think is the reputation? The general reputation. What will the people perceive of him?
Suka dokong bini orang.
Banyak skandal.
Okay, banyak skandal. Okay.
Suka dokong bini orang.
Suka wanita berusia.
Macam Prisari.
Macam-macam. Okay. Tapi maksudnya dia sebut, okay, can I say yang positively lah, seorang yang professional? Ya, she could be a womanizer, suka tak kira bantai je siapa perempuan pun dia sapu je. Okay, that one is set aside. Now, can I say that he is actually behaving professionally?
Yeah.
Tak. Yeah. Dia kata I actor kan. Bila I actor, I akan buat sebaik mungkin sebagai in my profession. So kalau that particular watak require me to be like this, I will do it. So seorang yang sangat professional. So that could be what people perceive of him. Korang nampak negatif je ya. Okay. Right? So bila reputation, you're talking about what people perceive of you. That is rather settled. Maknanya sebab orang nampak, orang keseluruhan sahabat. That's why dekat common law, dia refer kepada apa yang orang nampak. Okay. Now, bila kita cakap disposition is talking about dia punya inner traits dia. Dia punya personality dia. Alright? So, alright. Okay, personality, okay. kita tengok ni Lofa. What will be dia punya personality?
Attention seeker.
Charming.
Okay,
Tak
itu
nak tunjuk
public
muka
ke?
anak.
Itu public kena. Kau jangan confuse between general public dengan dia punya personality. Okay. Alright, tak nak yang tu lah. Nanti kan you are confused dengan general public. Attention seeker tu mungkin what public perceive of her. She might not be like that. Yeah? Because dia ada Insta. I rasa semua orang ada Insta tu attention seeker lah. Basically. I tak ada Insta. Kau orang ada Insta ke tak? Okay. So I tak ada. So I tak ada lah attention seeker. Okay. Basically. So now when you talk about disposition is mungkin okay, Abid Liu. What do you think is his disposition? Seorang yang generous?
Ya, generous.
Seorang yang generous.
Generous and dangerous.
Okay.
Jahat betul lah.
Okay.
Dia suka tolong orang.
Okay, dia suka orang generous, suka menginfak katakanlah. So that is dia punya personal trait. Dia seorang yang sabar. Okay? Dia contohnya lah, I bagi contoh macam tu ya. So everyone has dia orang punya personal traits. Okay? So that is disposition. So disposition is referring to something that is rather personal. Dia pemarah. Dia pemurah, ya. Dia pendiam. Alright? Okay, dia punctual. Okay, that is dia punya personal traits. Ya, tapi kalau general disposition will be what the people perceive of you. Contohnya, okay, what do you perceive politicians in Malaysia? Alright? Generally.
Liar. Penipu.
Okay, penipu ke? Pengampu ke?
Dalam banyak muka.
Generally lah. Ya, generally lah. Ya. Okay. That will be perception. Okay, that will be perception kan. So general public ni more kepada perception. Okay, disposition is actually the actual thing. Right? So, maknanya kalau you relate kepada these two situation, then you are dealing with character evidence. So you, isunya sekarang, boleh tak you bawa dekat court, okay, dia seorang yang pemarah. Ya, and okay, he is actually, okay, isunya ialah sama ada A, here, assault. Ya, issues, offense dia ialah assault. Boleh tak you bawa evidence relating to A being pemarah? That's the issue. So dia seorang yang pemarah dan the charge is assault. Right? The charge is assault. Now as a general rule, this is criminal case, you tak boleh bawa orang tu punya character evidence, dia punya disposition, dia punya reputation to show that he's guilty of an offense. Okay? Now, so that is the position. Sebab the duty of the court is not to charge the person sebab for the purpose of charging him, the duty of the court is actually to see whether he committed the actus reus and mens rea. Dan orang yang pemarah tak semestinya commit a crime. So that's the idea. Okay? So get the picture. Okay, itu isunya. Now, when you talk about character evidence, tadi I dah list down kan apa benda yang you nak tahu, iaitu okay, yang pertama ialah what is character evidence? Ada soalan tak dengan the meaning of character evidence? Ada tak persoalan on this point? Okay, tak ada. Now,
Puan.
Ya.
Yes? Kalau yang dia bawa yang pas criminal record tu macam mana?
Okay, pas criminal record. Okay. Alright, now as a general rule, as a general rule, we are talking about the general rule, character evidence not relevant, not admissible. Bila ada general rule, you kena faham there will always be exception. So we are going to discuss what are the exceptions to the general rule. Okay? Siapa tengok kereta ke apa ke? Komen kuat bunyi dia, okay? Okay, alright. So exception. So maknanya nanti tadi you tanya, boleh tak kita bawa dia punya previous conviction? It could fall under exceptions to this general rule. For the time being, you accept the fact kita buat stage by stage. Number one, the definition of character evidence. Yang aimnya ialah you nak bawa a person's character to prove he is guilty for assault. As a general rule, you tak boleh. Yang orang yang pemarah tak semestinya lakukan kesalahan. Yeah, so that's the idea. Okay, so that will be number one. So now number two, right? bila kita deal with character evidence, you have to bear in mind that character evidence here, mana color? Okay. That character evidence here is actually dealing with whose character? Whose character that is being protected by the provision dalam section 52 sampai 55. So character evidence dia jatuh dalam section 52, ya, 52 sampai 55. Now, as I told you tadi, general rule character evidence not relevant, not admissible. Maknanya ada protection by the law bila you nak bawa character evidence, especially bad character evidence. My question here is, who is being protected by section 52 to 55? Kalau you baca provision dalam Evidence Act, right? Section 52 to 55 protects the accused character, especially dalam criminal case. It protects the accused bad character evidence. The provision, ya, terutama dalam section 53 sampai 55 lah, 53, 54, 55. Right? So you're dealing with accused bad character evidence. So kita punya law dalam this particular chapter protect accused bad character evidence. So kalau you ada prosecution witness testify in the court, katalah kita ambil kes Bella. Ya, Bella punya kes you ada, okay. Of course you ada Bella. Okay, first an issue here is whether bonda tu commit abuse, ya, of Bella. So what happened here is that you panggil prosecution witness, katakanlah, remember one of the prosecution witness adalah staff.
Kawan dia. Ya. Yeah.
Kan, staff dekat kindergarten tu. Now if you recall, staff dekat kindergarten tu, masa dia being cross-examined by lawyer for Bella, apa dia tanya? Dia tanya banyak relating to character of the staff. Dia kata, you penipu, you tak punctual, you suka buat cerita. So basically, during cross-examination, what happened was that the lawyer for bonda basically asked question that concern with the bad character of the prosecution witness. Now, in this case, is that prosecution witness protected by section 52 hingga 55? Contohnya, ya, okay, the lawyer cakap, dalam cross-examination dia cakap, I put it to you that you sebenarnya suka buat cerita. I put it to you that you sebenarnya tak punctual, you letak kesalahan pada orang lain. So that will be the position. Kalau you all baca case Bella, ya, dia punya rentetan cerita case tu. So basically what happened dalam case itu, during cross-examination, the lawyer for the defense actually tarnishing the reputation of the prosecution witness. So dalam konteks ini, dia protect ke tidak di bawah section 52 hingga 55? The answer is no. Okay? So dalam section 52 hingga 55, the protection is given by the law only to the accused person. Get the picture? Faham? Okay, only to the accused person. So now, alright? So kita dah tahu apa itu repute character. Now, when you look at the law here, okay, ini kita dah tengok. There is a need for you to distinguish between character evidence dengan other relevant evidence. Number one, you kena boleh bezakan antara character evidence dengan similar facts evidence. Sebab dalam banyak-banyak kes, ada orang yang confuse character evidence dengan similar facts evidence. Okay? Now, what is similar facts evidence? You belajar last semester. So when you deal with SFA, apa dia SFA?
Kesalahan dia lampau.
Kesalahan dia lampau?
Ataupun dia macam mana dia kesalahan, bukan kesalahan, dia macam perbuatan dia yang
kesalahan berulang.
Kesalahan berulang. Similar
Apa ni tak boleh nak tulis ni kejap. Ish.
Repeated offence lah, puan.
Macam mana?
Macam repeated offence lah.
Repeated offence. So bila you cakap pasal similar facts evidence, dulu masa you belajar, what is actually being repeated?
Dia macam previous misconduct, accused previous misconduct.
Okay, you're talking about the accused previous misconduct relating to Okay, biasanya kita panggil apa? Dalam term yang you all biasa buat. You all adalah enforcement officer. SFE relates to what?
MO. Selalunya
MO.
kalau macam
Betul tak? The modus operandi. The modus operandi
ya.
is actually referring to how you commit a crime. So similar facts evidence refer to the modus operandi. Katakanlah you have V here. V here, sorry not V, A accused person. So you're the accused person here. Dia assault V1 in 2002. Dia punya MO ialah, okay, dia cari V1 dekat Taman Tasik. Lepas tu pretending that minta tolong V1 untuk cari barang dia yang hilang. So lepas tu dia bawa V1 at the secluded area and assaulted V1. He assaulted V2 in 2004. Also the same MO. Dia approach V2 dekat Taman Tasik Shah Alam. Tadi Taman Tasik Titi Wangsa, ni Taman Tasik Shah Alam. Minta tolong V2, tolong carikan saya punya barang yang hilang. Lepas tu dibawa V2 dekat secluded area and assaulted him or her. Okay, as a result, he was convicted for assault. Lepas tu V3, bila dia dah keluar jail, 2015. Also, dia approach V3 dengan cara yang sama and assaulted V3. Tapi dalam kes ini, he was charged tapi has to be released because tak cukup evidence. Jadi DNAA. Discharge not amounting to an acquittal. Lepas tu, you ada last one ialah V4. This one happened in 2022. Dia approach V4. The modus operandi is the same dekat Taman Tasik. Okay, dia kata minta tolong cari barang yang hilang. Lepas tu, assaulted her. Now, the charge is this one. Similar facts evidence is referring to you. Yeah, in the current charge, facts in issue here is whether A assaulted V4. That will be your facts in issue. Boleh tak you bawa evidence of what transpired in V1, V2 and V3?
Boleh, Doktor.
Boleh Doktor.
General rule dulu. Dengan
General
saya
rule?
general rule dulu.
General tak boleh.
General tak
Kenapa?
boleh.
Kenapa?
Sebab
Not relevant and admissible.
dia okay.
Kenapa not relevant, not admissible?
Due to presumption in the criminal justice system that the accused is presumed innocent until proven guilty.
Okay, ya. Yeah. Tapi relating to these facts,
Previous misconduct may happen if dia tak ada relate to the activities or mens rea of the current crime.
okay, you tengok, maksudnya you tengok dalam kes ini dia berlaku 2022 dekat Taman Tasik Section 7 Shah Alam. Yang ini Taman Tasik Titi Wangsa, ini Taman Tasik Shah Alam, ini katakanlah dekat Taman Tasik Setia Alam, katakanlah. Okay? Alright. So what happened here is that kalau you nak bawa A suing V4 for assault, you kena bawa semua evidence related to what transpired to V4 in 2022. Apa yang berlaku pada 2002, apa yang berlaku pada 2004, apa yang berlaku pada 2015 kepada victim yang berbeza tak ada kena-mengena dengan V4. Get the picture? So because of that, as a general rule, it is not relevant, not admissible. Section berapa saya cakap ni? Section 5. Section 5 kata you boleh bawa keterangan dekat mahkamah sekiranya dia related to the facts and issue or relevant facts. As a general rule, what transpired, what happened to V1, V2, V3 pada tahun yang lain, di tempat yang lain tak ada kena-mengena dengan V4. Betul tak? In the current case. So that's the idea. So when you talk about similar facts evidence, dia tidak ada kena-mengena kecuali yang menghubungkan offence V1, V2, V3 with the current charge V4 adalah the modus operandi, the way he committed the crime, right? So when you talk about similar facts evidence is brought into the court and regarded to be relevant because the way the crime is being committed is the same, right? So that's how you talk about SFE, the modus operandi. So dia tak ada kaitan dengan character evidence. You get the picture? Dia tak ada kaitan dengan disposition ataupun ataupun reputation of the accused person sebab dia deals dengan modus operandi how he commit the crime. And that is where the link is. Yeah, the link will be how is the crime is committed. Get the picture? So that's why dalam kes tube home, ya, kalau tengok dekat lecture note tu, dalam kes tube home, dalam kes mood publishing, of course that's all civil case. Dalam kes itu, apa-apa attempt untuk bawa evidence of character evidence as a general tidak boleh dibawa kecuali you nak bawa dia dalam ikut SFE. So SFE you're referring to the previous misconduct. What happened dalam kes mood publishing dia adalah breach of copyright. So you have the defendant here breach copyright, maknanya dia dah publish kata video, dia ambil video lepas tu dia publish. Dia dah kena saman. Lepas tu setahun kemudian dia buat lagi benda yang sama pada video yang lain. So you nak bawa dia to reflect similar facts evidence. Okay? Dan indirectly you try to bring it under bad character. As a general rule tak boleh. Ya, you tak boleh bawa to reflect bad character tapi you boleh bawa dia to reflect similar facts evidence. Okay? So this is the relationship between similar facts evidence dengan bad character evidence. You tak boleh bawa untuk show bad character. Tapi you boleh bawa untuk show the similar MO. Okay? Alright. So harap faham apa tu SFE because nanti kita akan jumpa lagi SFE bila kita masuk section 54. Okay? Satu lagi yang you all kena faham ialah ada beza walaupun ada perkaitan antara character evidence dengan evidence of motive. Right? So if you refer to evidence of motive, okay, this one actually I'm referring to the lecture note you yang tu, ya, if dia kat bawah tu. So, evidence of character, if you bring evidence, okay, character evidence versus motive. Now, this proposition is actually reflected dalam kes Wong Po Hing. Now, what happened in the case of Wong Po Hing? Ada tak Dr. Mazlina explain Wong Po Hing kat you all? Ada tapi tak ingat? Atau tak ada? Wallahualam dah lama ya? Okey. Kira 3 tahun, 4 tahun gitu. Okey.
Tak ingat.
Okay. Now, what happened in the case of Wong Po Hing? You have the accused person here, bapa dia. Dia ada anak dia daughter who is katakanlah 10 years old. Now, what happened in this case is that accused person here have been sexually assaulting dia punya anak. Okay. Accused person ni dia ada wife. Dia orang duduk dekat rumah panjang. So, they stay in a rumah panjang. So, what happened was that the wife got to know that the accused person is assaulting his own daughter. So, the wife here complain, beritahu dekat orang tua. So, orang tua adalah orang ketua dekat rumah panjang tersebut. So, what happened was that this orang tua call A, panggil A tu. Lepas tu dia meeting, dia cakap dekat A, kalau saya dengar sekali lagi kes you buat macam gitu dekat anak you, I will bring this matter to the police. Dia kata kita akan report kes ni, nanti you akan kena charge for rape against your daughter. Okay, so A janji tak nak buat lagi. Now what happened? 3 weeks from then, 3 minggu lepas tu, katakanlah, A balik daripada berburu ke whatever. So dia balik kat rumah, dia penat. So dia panggil anak dia untuk massage dia. Ya, tolong urut abah, ya. Bila dia massage kat dalam bilik. Of course lah, dekat rumah panjang tu kan jadi bilik-bilik je kan. Tapi dekat sini dekat dalam kelambu. Dia suruh anak dia massage dia, tiba-tiba anak dia menjerit. Mak dia ada kat dapur. The mother was actually cooking in the kitchen. So what happened? Bila mak dia datang tengok dekat pintu, dia nampak husband dia just assaulted the daughter. Right? So mak dia nampak. So mak dia give him a stern face, lepas tu mak dia terus keluar. Right? Now, what do you think in the mind of the accused person bila nampak wife dia macam tu? Apa agaknya dalam kepala otak accused person? Wife dia pandang dia dah buat kesalahan. Okay, wife dia terus keluar rumah. Agaknya dekat kepala A ni, apa agaknya?
Report polis.
Mesti aku punya
kantoi.
Wife ni, okay. Aku dah kantoi lah, right? Mesti wife aku ni nak report dekat orang tua. Alright? So bila wife tu balik petang tu, accused person dengan anak dia tak ada dah kat rumah. Lepas tu accused person balik, anak dia tak balik-balik. So what happened was that they make a search and they found the body of this girl, lebih kurang 1 atau 2 batu daripada rumah tu dekat dalam well. Dekat dalam perigi buta lah yang dah ditinggalkan. Right? So, now the facts and issue here is whether accused person bunuh anak dia. That's the facts and issue. Now, the prosecutor want to bring in the evidence of W and orang tua. Boleh tak? Boleh tak? Prosecutor nak bawa W dengan orang tua dekat court.
Boleh?
Okay, you rasa nak bawa dia dalam section mana? Agak-agak lah section mana? Takkanlah nak belajar satu semester dengan Dr. Maslina tak keluar sectionnya. Agak-agak section mana? Yang related kepada soalan ini. Korang ni betul-betul lah. Dah nampak kat situ motif, tentulah motif section berapa? Motif?
6 doktor. Section 6 ke?
Section berapa motif?
Section 8.
Okay, section 8. So prosecutor nak bawa accused person, nak bawa the wife and orang tua to give evidence in the court to show that accused person ni ada motif untuk bunuh anak dia. What is the motive? To make her silent so that she will not going to report what happened to her. So there is a motive to kill her. Alright? So the prosecution nak bawa W and orang tua to bring evidence of the fact that the accused person has a motive to kill dia punya daughter. Now what happened in this case is that the defense bring in section 54. Okay, now let's look at section 54. Cuba baca section 54 subsection 1. Someone give me section 54 subsection 1. Okay.
Previous bad character not relevant except in reply. Subsection 1. The fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant.
Okay. Now, bila you dengar that particular provision, the first part of that particular provision, what does it say? Dalam kes criminal,
tak terima.
Alright. Dalam kes-kes criminal proceeding, the fact that the accused person has a bad character is not relevant. So meaning to say under 54 subsection 1, there is a shield protecting the accused person from bad character evidence. Sebarang bad character evidence tidak boleh dibawa ke mahkamah because this is the general rule. So the general rule under section 54 subsection 1 is that you cannot bring in bad character evidence. An accused person is protected against bad character. Get the picture? So now, apa yang lawyer dicakap dekat court ialah, you tak boleh, I nak rely 54 subsection 1 for my client because kalau you bawa evidence of orang tua dengan wife ni kat court, they will show that I am a very bad father. I involved in sexual relationship with my daughter. So I am a bad father. So this is injuring my character. So dia nak pakai general rule under 54 subsection 1. You get the picture? Nampak tak kat situ? So you see here, there is a clash between evidence of motive bawah section 8 dengan evidence of bad character under 54 subsection 1. Now, which one will prevail? Now, the law says that if you have two provisions that talk about the same matter, satu provision benarkan evidence itu dibawa ke mahkamah and the other one prevent it from being tendered, the law says that you have to give effect to the provision that allows the evidence to be tendered in court. So maknanya, evidence of motive can be tendered in court walaupun ada evidence of bad character. So that's the idea, right? So in this case, at the end of the day, the wife and orang tua can testify in the court to show motive and the evidence of general rule. So and the general rule that protects the accused person against bad character is not relevant, not admissible. It's not applicable in this case. Get the picture? So dekat situ I nak relate kat you the relationship between character evidence and the evidence of motive. Got that? Boleh? Okay. So what we have covered so far, number 1 will be what does it mean by character evidence? Number 2, the relationship between character evidence dengan SFE. Number 3, the relationship between character evidence and any other provision, for example, evidence of motive. Okay, ada soalan atau tidak? Up to this stage. Tak ada soalan?
Puan,
Ya.
Puan,
Yes.
kalau apa tu, yang macam bad character ni kan, walaupun dia tak relevan, tapi tengok selalu digunakan oleh defense lawyer kan. For example macam kes Datuk Seri Zahid Hamidi yang dia menggambarkan PA dia tu kan yang major apa tu, jenis tak dengar cakap lah, apalah. So macam it still can be testified in the court kan, walaupun kalau nak kira section tadi tu lah 54 subsection 1 tu. So macam mana sebenarnya?
Alright, so when you deal with character evidence, sebenarnya apa yang berlaku in reality, okay, that's why it's very important for you to identify whether you are dealing with good character evidence or bad character evidence. Okay, now when you talk about, okay, now good character evidence, dalam kes Zahid Hamidi, dalam kes Yayasan Akal Budi tu, you rasa banyak tak dia bagi good character evidence? Dia cakap apa? Especially in his defense, dia cakap, saya ni sebenarnya banyak duit, right? Saya create this particular Yayasan Akal Budi for the purpose of charity. Sebab dah janji dengan arwah bapa saya, I want to donate, right? I'm a very good person, so I donate, I use my own money. I was a businessman prior to become a politician. So I use my money, okay, set up this Yayasan Akal Budi for the purpose of charitable thing. Then I buat tahfiz, I buat sekolah tahfiz, right? So what he did was that he was giving good character evidence. You get the picture? Now, good character evidence, what is the position of good character evidence? And this is a criminal case. Bila you cakap pasal good character evidence, you got to look at section 53.
53.
Yeah, section 53 talk about good character evidence. Tadi I beritahu kat you, generally good character tak boleh bawa kat court. Okay, because I'm talking about civil case as well as criminal case. Dalam civil case, you tak boleh langsung bawa character evidence good or bad. Dalam civil case, okay? Tapi dalam criminal case, ada lain sikit proposition. That's why you got to identify case you case civil ke case you case criminal. Okay? Yang kedua, you kena identify sama ada you are talking about good character ke bad character. Yang good character evidence, bad character evidence will be relevant dalam criminal case. Now, dalam section 53, what have you found? In criminal cases, previous good character relevant. In criminal proceeding, the facts that the accused person is of a good character is relevant. So dalam criminal proceeding, good character evidence is always relevant and admissible. So bila Zahid Hamidi bagi tahu dekat court, right? Ya, dia beritahu dekat court, saya seorang yang pemurah sebenarnya, saya selalu donate dekat orang. Okey, setiap bulan puasa saya donate. Lepas tu masa hari haji saya akan bagi 10-100 ekor lembu. Lepas tu saya bangunkan sekolah tahfiz. So he is actually giving good character evidence. Now, in the criminal law, good character evidence is relevant and admissible. Now, when you deal with bad character evidence, tadi kita dah tengok bad character evidence under section 54 subsection 1 ada general rule, iaitu tak relevant, tak admissible. So it means that you cannot bring in bad character evidence. I cakap kat you tadi, bad character evidence siapa yang you protect di bawah section 54? Bad character evidence yang siapakah yang you protect di bawah section 154? Sorry, di bawah section 54. Accused person. So you're talking about this provision is protecting the accused person punya bad character. Now your question just now, okay? PW. Dia dalam kes Zahid Hamidi, PW punya reputation, punya disposition was actually being tarnished by the defense lawyer. Dia cakap, dia punya secretary dia punya apa? Dia punya PA dia tak dengar cakap, degil buat kerja sendiri, memang apa-apa semua. So you are talking about her reputation, her disposition. So the witness boleh ke tidak diprotect di dalam section 52 sampai 54. So adakah maksudnya dia boleh cakap macam-macam pasal character of the witness? Yang ini nanti kita akan tengok dia tak boleh. Bukan senang-senang juga Okey. Dia tak dia akan nanti kita akan tengok di bawah section 146. Ya, maknanya boleh tak you musnahkan character of the witness 146 dan kita akan cross refer juga dengan section 54 sub 2 sub B. Ya, nanti kita akan cross refer. Get the picture. Boleh? So tadi jawab soalan kepada jawapan you. Okey, dalam section 146, you boleh tanya banyak soalan dalam cross examination. So apa yang berlaku? Saksi tu kena cross examine, di cross examine oleh lawyer Zahid Hamidi yang mengatakan bahawa dia seorang yang degil ke apa ke tak ikut peraturan semua. So boleh ke tidak kita akan tengok dalam section 146 dan apakah impact dia kita akan tengok dalam section 54 sub 2 sub B. Get that? Boleh? Boleh? Aizani? Sudah. Okay. Alright. So get the picture. So tadi, so we are looking into this. Okay, what happened is that sekarang dah pukul 9.42. I habis sekarang pukul 10.30 ya. I bagi kat you 5 minit break sebelum kita move on. Ya? 5 minit break sebelum kita move on. Okay, boleh masuk balik?
Boleh doktor, boleh.
Juga dia tak pergi mana-mana pun kan.
Boleh,
Boleh.
Okay. Now, so we proceed on with character evidence. Alright, I mentioned a little bit on character evidence in civil case. Right, as a general rule, Section 52 dengan Section 55 adalah provision yang deal with character evidence in civil case. So dalam civil case, basically, evidence of character, character dalam civil case, both good character evidence or bad character evidence is not relevant, not admissible, right? As a general rule dalam civil case, good or bad character evidence is not relevant, not admissible, okay? Kecuali ada exception under Section 52 kat situ, apabila character is actually related to the facts in issue or relevant fact. Okay, this is for example dalam case saman malu, defamation case. Kalau you ada defamation case, you all tak ada buat civil kan? You all tak ada buat civil. So dalam saman malu, kalau you nak sue a person for defamation, contohnya you have quite a lot of cases yang defamation. Contohnya you kata A, right? Okay, you have defendant, you have plaintiff. Plaintiff ada orang yang sue, defendant orang yang kena sue. Plaintiff sue defendant sebab defendant maybe keluarkan pernyataan dekat dalam surat khabar bahawa plaintiff ni seorang yang tidak bermoral. Iaitu dia suka frequenting prostitute katakanlah, ya. Seorang yang tidak bermoral. So what happened here is that the plaintiff here is suing the defendant for defamation. Dan dalam konteks law relating to defamation, elemen yang perlu dibuktikan ialah pernyataan yang dibuat oleh defendant here is tarnishing the reputation of the plaintiff. So what you got to do, dia mesti ada publication, iaitu the statement tersebut mesti dipublish. Katakan dipublish dalam surat khabar ke, surat layang ke, dalam surat lah, pokoknya dia seorang tidak bermoral. So there must be publication. And this publication is actually tarnishing the reputation of the plaintiffs. So dalam konteks ini, the facts in issue is actually reputation of the plaintiff. So dia adalah elemen dalam proving defamation. That's why dalam konteks ini, reputation, disposition, character of the plaintiff will be relevant. Dalam kes lain, tidak boleh. Kat mana-mana lah dia publish.
Media sosial okey ke?
Tak boleh lah. So kalau you publish kat media sosial, bila you cakap pasal defamation, you are talking about publication, you are talking about libel atau slander, you publish kat media sosial bahawa A adalah seorang yang tidak bermoral. Sebab apa dia tidak bermoral? Dia suka pergi frequenting prostitute katakan. Alright? So kat situ, publication tu maksudnya, adakah publication tersebut impact reputation of the plaintiff or not? Bila you masukkan dekat dalam media sosial, dia impact reputation of the plaintiff, then the plaintiff can sue for defamation. So maknanya dia impact terhadap reputation dan disposition, the impact terhadap character of the accused person tu adalah faktor yang perlu dibuktikan dalam kes. Dia adalah fakta persoalan. Get that? So because of that, dia perlu dibawa masuk dekat court. Ya, maknanya evidence relating to character boleh bawa masuk sebab dia adalah satu elemen yang perlu dibuktikan. Okay? Dan secondly, dalam civil case, you boleh juga bawa character evidence sekiranya you nak assess damages. Ya, under section 55, you want to assess damages. Assessment of damages ni apa? Ya, maksudnya kalau orang tu sue for defamation, alright? So berapa banyak kau nak bagi dia ganti rugi? Okay? Baru-baru ni kalau you baca surat khabar, ada satu kes yang defamation yang Khalid Samad ke? Ya? Khalid Samad ada buat kenyataan dekat dalam surat khabar defaming someone, ya? Dia buat kenyataan. So dia kena sue dan dia disuruh bayar 100 ribu kepada orang yang sue dia. Okay? So dalam konteks itu, amount 100 ribu tu boleh bergantung kepada character of the party. I bagi contoh dalam kes Sanderson ni. Now, apa yang berlaku dalam kes Sanderson ni adalah, okay, Sanderson ni bekerja dekat rubber badan getah ya. Badan apa benda yang getah lah, relate kepada getah. Dan dia actually take bribe. Ya, he took bribe, ambil rasuah, dan dia sekarang ni sedang subject to domestic inquiry. Maksudnya ada siasatan dalaman dikenakan dan dia ada internal punya proses to determine whether he's guilty or not for taking bribe. You all ada kan dalam government officer, kalau you commit a particular action ke apa, there can be internally dalam you punya department ada action, civil action to determine whether you committed that crime or not. So ni berlaku pada dia. Issue relating to him taking bribe lepas keluar, and Malaya Times ni surat khabar ni keluarkan satu artikel. Dia keluarkan satu artikel yang menyatakan bahawa Sanderson ambil bribe. Ada seseorang yang orang penting di dalam badan getah tersebut ambil bribe. Dia keluarkan artikel. Dia tak sebut siapa nama. Tapi kita tahulah tu adalah Sanderson. Now what happened in this case is that, Sanderson sue this particular surat khabar for defamation. Maknanya kenyataan yang you keluarkan dalam artikel tersebut tarnish my reputation. So I'm suing you for defamation. Bila dia sue for defamation, the finding of the court dapati bahawa ada defamatory statement. Maknanya ada defamation. Dalam artikel ni memang ada defamation. So, bila ada defamation, court kena proceed untuk determine berapa banyak damages yang perlu dibayar oleh syarikat tersebut kepada Sanderson ni. Dalam konteks ini, court tengok, memanglah ada defamation tapi you memang ambil bribe. Memang betul. So, court assess damages itu ke berapa? Court bagi dia RM1 je. Reputation you, character you, determine how much money they pay for compensation. So, court tengok you punya, dalam kes tu memang betul ada defamatory statement. Memang betul the defendant tu bersalah dalam konteks ini. Tapi bila I tengok you punya perangai, you punya watak, memang you patutlah pun. Macam tu. So, instead of dia minta 50-60 ribu, court bagi dia RM1. So, that is actually character evidence. So, this what happened dalam civil case. So, dalam civil case, as a general rule, tidak relevant, tak admissible, kecuali dalam dua contoh ini. Defamation dan assessment of damages. Get the picture? Ini untuk general knowledge lah ya. Tak berapa nak penting sangat because you all are enforcement officer. Okay? Dan banyak deal dengan criminal cases. Ya, apa dia soalannya?
Puan, maksudnya kalau dalam kes defamation ni, Saman Malu ni, yang dia kata dia tuntut 10 juta lah apalah tu, maksudnya suka hati dia lah nak tuntut berapa, but at the end, the court will decide. Macam tu? Betul.
Sebab dia tak kira berapa banyak dia nak tuntut. Maknanya dia akan tuntut dia akan letak paling banyak pun dia tuntut. Akhirnya court akan decide. Right? Kalau dekat luar negara ni orang memang sampai juta-juta. Right? So kalau dekat Malaysia ni, dia mungkin tuntut juta tapi court akan bagi dalam 100 ribu, 200 ribu. Ya, bergantung kepada budi bicara mahkamah. Kalau kita punya kes sampai juta-juta kan.
Tu Maidin kena tu. Puan, Maidin kena.
Yalah kan yang dia dengan apa?
Caprice, topi beras.
Dia perasan macam dia perasan yang orang kata dia kan.
Prof nak tanya, dia ada limit ke? Ada limit ke?
Limit apa?
Limit yang apa berjuta-juta tu ke?
Sebenarnya bila you cakap pasal claim tu tak ada limit. Suka hati dia nak letak berapa. Dia nak letak 5 juta, 6 juta, 10 juta. Dia merasakan bahawa reputation dia sangat besar. Right? So that's why dalam kes-kes yang you have very high profile person, so reputation dia tu sangat penting bagi dia, especially dia dalam profession yang memang memerlukan reputasi dia. dan you punya statement tu injure my reputation very very badly. Contohnya reputation, okay, you involved dalam saham-saham katakan. Lepas tu keluar dekat dalam surat khabar kata you tak boleh dipercayai, you menipu saham-saham. So adakah dia affect so much you punya sara hidup? Okay, dia akan affect so much you punya untuk dapatkan sara hidup, livelihood and all that. You akan basically akan minta banyak. Kalau you adalah orang yang high profile, you akan minta lagi banyak lah. Tapi kalau you orang yang som-som kuku, orang keliling-keliling je tahu, you minta lah juga. Tapi you akan dapat sikit lah. Ya, yeah? So it depends on you punya reputation. How much it affects you punya reputation. So very subjective. You, okay, nak letak berapa banyak juta tu is up to you. Korang letaklah banyak-banyak juta pun. Tapi at the end of the day, court akan tentukan berapa banyak. Yang sesuai. Okay? Boleh? Alright, ada soalan lain? So this will be, okay, this will be the position of character evidence in civil cases. Now let's look at character evidence in criminal case. Ya, tadi I tengok kat you. Okay, yang paling penting you kena tengok case you, case civil ke case criminal. Sekarang kita masuk dalam case criminal. Sorry, okay, dalam case criminal, right? Good character evidence. We're talking about good character evidence. As the general rule, tadi kita dah baca section 53. Good character evidence is always relevant in criminal proceeding. Maknanya, dia adalah plus factor untuk kita beritahu kat court, kita orang yang baik. That's why, bila Zahid Hamidi kata dia seorang yang baik, dia suka derma, dia buat sekolah tahfiz, sebenarnya boleh dibawa masuk dalam section 53. Sebab, presumption ialah, a person who has led a morally sound and lawful existence less likely akan commit crime. So kalau dia orang yang baik, kita selalu tak kita dengar cakap, dia tu nampak baik kan, tak sangka rupa-rupanya dia buat macam gini. Okay, you tengoklah kes Abid Liu. Abid Liu kena charge for sexual assault ataupun sexual offence, bukan ke dia seorang yang baik, dia tak buat macam ini. So basically, that reflect the good character evidence has an impact. Maknanya orang tak sangka orang yang baik macam gini commit crime. Right? So that's what it meant. Because the presumption is that, maknanya the presumption is that orang yang baik dia takkan buat benda-benda macam ni. Tapi kita orang tahu kan manusia ni hidup dua alam. Ya, dia akan tunjuk dekat orang dia baik. Tapi sebenarnya dia adalah serial killer. Kan? So itu memang cara dia lah ya. Tapi generally this will be the proposition. Get the picture? Yeah? So good character evidence is always relevant. Right, kat sini kita tengok ada case law kat sini. Good character may indicate the innocence and criminality of the accused person. Maknanya dia ada. Maknanya orang yang baik tu kita punya perception ialah dia takkan buat benda yang jahat. So there could be a situation. Dan kalau you bawa evidence of good character, you must bring positive proof of your excellent character. Look at the case of Zahid Hamidi. Zahid Hamidi claim dia apa? Dia seorang yang pemurah, dia guna duit dia selalu donate charity, ya. Dia suka menderma, lepas tu dia buat sekolah tahfiz. Dia kena buktikan benda tu. Apa yang dia buat? Dia bawa judge tu pergi tengok sekolah tahfiz dia, betul tak? Ya, dia bawa judge tu. Maknanya, bila dia bawa judge tu pergi sekolah tahfiz dia mengemukakan bukti positif. Maknanya, betul, saya tak cakap kosong. Saya memang seorang yang penderma, seorang yang baik. Buktinya inilah sekolah tahfiz yang saya create. So you are bringing in positive proof of your good character. Get the picture? So maksudnya, kalau you bawa good character evidence, you kena buktikan you punya good character evidence by tendering bukti. Dengan membawa bukti. Untuk membuktikan bahawa you adalah orang yang good character. So far get the idea? So bila dia kata nak ziarah-ziarah dekat sekolah tahfiz ke apa tu, ziarah masjid ke apa tu, benda tu memang sebenarnya ada implikasi dalam undang-undang. Memang disuruh. Yeah, you get that? Having said that, kena faham bahawa evidence of good character and general disposition cannot outweigh positive evidence with regards to the guilt of the person. Ini maksudnya apa? Now, if you look at the situation, okay, katakanlah you have here, an accused person here being charged for corruption. Ya, being charged for corruption. Elemen yang you kena buktikan adalah actus reus and mens rea. What happened at the prosecution stage? Okay, by the way, berapa stage yang ada dekat criminal case? Criminal, bicara criminal, bicara jenayah. Okay, ada dua. So, stages in criminal trial ada dua. Yang pertama ialah prosecution stage. Right? Now, you got to prove actus reus. Siapa yang buktikan actus reus? Mens rea.
Prosecution.
Okay. Dekat prosecution stage, prosecution kena buktikan actus reus and mens rea. Dia buktikan actus reus dengan mens rea dengan cara yang macam mana? Macam mana dia buktikan actus reus dan mens rea? Apa yang berlaku dekat prosecution stage? Come on. Apa yang berlaku dekat prosecution stage? Korang takkanlah tak tahu. Okay? Ada PO, PO pun ada.
Evidence lah to support actus reus mens rea and then to prove prima facie tu.
Okay. So maksudnya banyak sangat tu. Okay, satu-satu. Apa yang prosecutor buat? Prosecutor bawa evidence. Betul tak? Setuju?
Betul.
Prosecution bawa evidence. Okay. Evidence apa yang prosecution bawa? Bentuk-bentuk dia.
Oral, dokumen, betul kan?
Prosecution witness. Betul? Dia akan bawa prosecution
Saksi.
witness. Dia akan bawa saksi dia. Lagi? Dia akan bawa apa-apa dokumen yang berkenaan. Betul? Dan kalau ada real physical evidence, dia akan bawa real physical evidence. Right? Because prosecution here is making an allegation that the accused person is a corrupt person under whatever law. So, dalam prosecution stage, it is the prosecution that bring all evidence in the court. Kita panggil ni sebagai prosecution here. Why? Kenapa prosecution yang kena bawa? Sebab the prosecution bears the evidential burden of proof. Yeah, because the prosecution, evidential burden of proof refer to apa? Tanggungjawab bawa bukti. You got that? Evidential burden of proof. So because at the prosecution stage, the prosecution has the evidential burden of proof to bring evidence in the court. Evidence yang dibawa ni will support his case. Support untuk buktikan actus reus dan mens rea. Now, kalau dia bawa evidence in support, tiba-tiba orang tu cakap terbalik daripada dia, orang tu sepatutnya bawa evidence untuk menyokong actus reus dan mens rea, tetapi orang tu turn hostile, apa jadi kat dia? Apa yang prosecutor buat? Anyone? Pernah deal? Pernah jumpa keadaan ni? Tak pernah? You all punya saksi semua baik-baik belaka?
Bercakap.
Okey je.
Okey je. Alright. Kalau you sepatut panggil saksi yang beri keterangan yang sokong you, tiba-tiba saksi you ni beri keterangan sokong defense. Apa yang berlaku? You boleh take action to impeach. Ya? To impeach the credit of your prosecution witness. So this is where you have impeachment proceeding. Your witness has turned hostile. Okay, get that. Dekat prosecution stage, you have the legal burden of proof, kan? You have the legal burden of proof. Tanggungjawab buktikan case. Now what happened? Now why am I discussing this one? Kenapa saya discussing tadi? Anyone can remind me balik? Kita tengah discuss, let me see. Okay, ya, faham. So, I cakap tadi, kita tengah discuss this point, ya. Yang kita discussing this point. Okay, evidence to outweigh. Okay, ya, this is the part kita nak tengok. Kalau evidence to outweigh, if you bring evidence in the court to prove the case, character evidence cannot overcome that, ya. So, maknanya, apa yang berlaku ialah, dalam case corruption, prosecution here is making an allegation A commits crime. Prosecution akan bawa saksi-saksi berkenaan case tersebut. Lepas tu, court akan evaluate. Ya, court akan evaluate. Okay, katakanlah upon evaluation, prima facie buktikan. Prima facie buktikan what happened to the case? What happened to the case now? Kalau dah prima facie kat situ, you pergi
Enter
dekat
defense
defense.
stage.
Okay, you pergi
Defense
dekat
stage.
defense stage. So you pergi dekat defense stage. Dekat defense stage, who bears the evidential burden of proof? Evidential burden of proof at the defense stage. Siapa yang pegang beban tanggungjawab membawa bukti dekat defense stage?
Defense counsel.
Okay, you have defense counsel. Tanggungjawab bawa bukti. So siapa yang dia akan panggil? Accused person atau defense witnesses. Okay. Now, katakanlah accused person dalam konteks ini beri keterangan dekat mahkamah. So, accused person testify in the court dan dia beri keterangan with regards to his good character evidence. Macam Zahid Hamidi. Right? Zahid Hamidi dekat defense stage, dia beri keterangan bahawa dia seorang yang berperwatakan mulia. Ya, baik. So, dia ada tahfiz and all that. So, dia bawa good character evidence dan dia bawa bukti yang dia memang good character. Now, kalaulah semua elemen prosecution, actus reus and mens rea itu dapat dibuktikan dengan evidence oleh public prosecutor, evidence of good character of the accused person tidak boleh dislodge the conviction. You get the picture? Maknanya, you punya good character evidence mungkin relevant and admissible. Tetapi dia tidak cukup kuat untuk menolak bukti-bukti yang telah dibawa oleh prosecution yang dapat buktikan actus reus and mens rea. That's what it meant by that proposition. You got the picture? So, walaupun dia relevant, tunjuk good character, remember ya, good character evidence to reflect kepada, okay, dia orang yang baik, therefore dia tidak commit crime. So, that's the idea of good character evidence. Okay? Tetapi, walaupun you bawa good character evidence, dia tidak semestinya boleh dislodge the case of the prosecution. Dia tak cukup kuat. Kalau prosecution ada case yang kuat, semua bukti-bukti dibawa tu menyokong conviction, good character evidence tak boleh nak dislodge that. Get the picture? Faham ya? So that is what it meant by this proposition. Ya, yang ini ya. So, cannot outweigh the positive evidence with regards to guilt of a person. So maknanya kalau cukup bukti yang dibawa oleh prosecution, you kena convict dia walaupun dia bawa evidence of good character. So sekarang ni kita tengah tunggu Zahid Hamidi apa cerita dia ya, kes Yayasan Akal Budi. Dia tengah relax tu sebab VLN tu dia dah dapat acquittal kan, prima facie dekat third level, dekat prosecution stage kan, VLN. Ya, VLN dekat prosecution stage dah dapat prima facie. Okay, so that is the position. Okay.
Syed Saddiq puan kes baru.
Betul. Terbaru Syed Saddiq terbaru Syed Saddiq prosecution stage convicted. So dia nak masuk dekat defense stage. Right? So, dan dia dah cakap dah, I akan beri keterangan bersumpah. Okay? Now, bila you cakap pasal accused person dekat defense stage, dia ada option dia berapa? Bila you cakap accused person?
Tiga lah.
Okay, dia ada 3 option. 1, keterangan bersumpah.
Keterangan bersumpah.
1, tidak bersumpah.
Tidak bersumpah.
1 lagi?
Berdiam diri ya?
Okay, he kept silent. Ya, dia berdiam diri. Siapa tu? Anak siapa tu agaknya? Kejap saya tutup suara dia. Mute. Okay. Okay. Right. So you get that ya. So Syed Saddiq kata dia nak beri keterangan bersumpah. Right. Najib beri keterangan bersumpah. Zahid Hamidi beri keterangan bersumpah. Okay. Anwar Ibrahim beri keterangan tanpa sumpah. Kes Basikal Lajak beri keterangan tanpa sumpah. Right. So dekat situ ada impact dia ya bila you evaluate at the end of the day. Okay. So saya confident je. Okay, kita akan beri keterangan bersumpah. Okay. Alright. Okay. Now let's look at good character evidence. So that is so far as good character evidence boleh bawa dekat mahkamah. Dan good character evidence ni biasanya kita boleh gunakan untuk tujuan mitigation. Mitigation tu apa? What is mitigation? Nak kurangkan sentencing ya, nak kurangkan sentence ya. Kalau you can be sentenced to 20 years of imprisonment, Sebab you kata you are good character, mungkin dia boleh reduce kepada 15 tahun. So that is the purpose of mitigation. Ya, you bawa good character evidence untuk kurangkan sentencing apa?
Hukuman.
Ya,
Hukuman.
kurangkan hukuman tersebut. Ya, so kat sini kalau maknanya guilty plea reflect good character. Maknanya you mengaku bersalah, save the court the energy and time, okay, then sentence will be reduced. Ya, kalau you ada previous conviction, you rape sampai 10 kali, right? Tiba-tiba you nak kata saya bertaubat dan apa dia tak akan effect. Okay, so that will be the position. Okay, get the picture. This will be the use of good character evidence. Okay, right. Now, the second part of this situation is when we deal with bad character evidence. So tadi maknanya dalam criminal trial, dalam criminal case, kita kena tengok satu good character evidence. Good character evidence, general rule, relevant and admissible. Okay? Sectionnya 53. Then, when we talk about bad character evidence, so bad character evidence lah yang kat sini lah kita nak tengok. Now, bad character evidence, kita ada dua provision that talk about the general rule. The general rule satu ialah dalam section 54 sub 1. Tadi kita dah baca. Dalam section 54 sub 1, dia kata bahawa bad character evidence is generally not relevant, not admissible. Yeah? So, section 54 here is actually Section 54 sub 1 provides you with a general rule, not relevant, not admissible at all stages of crime. Maknanya, bad character evidence tidak boleh dibawa langsung pada mana-mana stage bicara. Be it the prosecution stage ataupun defense stage. Maknanya, dekat prosecution stage, the prosecutor, ya, dekat prosecution stage, the public prosecutor ni tak boleh soal saksi dia untuk bawa bad character evidence of the accused person. You get the picture? So this will be the proposition. Of course lah, bila dekat defense stage, the public prosecutor tak boleh nak cross-examine the accused person with regards to his bad character. So, dalam section 54 subsection 1, the general rule tidak membenarkan bad character evidence berlaku pada setiap waktu. General rule-nya. Now, kalau you baca section 54 subsection 2. Now, 54 subsection 2 kalau you all baca, can someone read me 54 subsection 2? Sebelum, jangan ABC tu tak payah. 54 subsection 2 sahaja.
Madam.
Ya. Apa tadi?
A person charged and called as a witness shall not be asked, and if asked, shall not be required to answer any question tending to show that he has committed or been convicted of or been charged with any offence other than that wherewith he is then charged or is of bad character, unless.
Okay, alright, stop situ. So, section 54 subsection 2 refer kepada siapa? A person charged and called as a witness. Apa yang you nampak dekat situ? A person charged and called as a witness.
Masa defense cases.
Alright. So, 54, maknanya dalam section 54 subsection 2, you are talking about the accused person. Number 1, elemen yang pertama dalam 54 subsection 2 will be, right, I padam sikit. Sekejap. Okay, dalam section 54 subsection 2, you are dealing with number 1. You are talking about an accused person. An accused person. Sebab a person charged, an accused person. A person charged refer to an accused person. Number 2, and called as a witness. So maknanya what kind of evidence is an accused giving at this stage? So it is a defense stage. Number 3, called as a witness, accused person choose to what? To give sworn evidence. Get the picture? Accused person choose to give sworn evidence. Yeah, a person charged, you're referring to the accused person, and called as a witness, maksudnya dekat defense stage, and he gives sworn evidence, called as a witness, shall not be asked, and if asked, dia tidak boleh ditanya, dan jika ditanya, any question relating to whether he has committed an offence or convicted of an offence, or anything that relate to bad character. Maknanya dia tidak boleh langsung ditanya berkenaan dengan apa-apa yang relate kepada bad character evidence. So number 4, he cannot be asked relating to bad character evidence. Kalau ditanya, dia boleh tak nak jawab. Kalau dipaksa, you sebagai defense lawyer, objection yang Arif, there's a shield protecting the accused person. So dalam section 54 subsection 2 here, there is a shield. There is a shield protecting the accused person against bad character evidence. You get the picture? There is a shield protecting the accused person against bad character evidence. So he should not be forced to testify or to respond to any question that relates to his bad character. Now, dalam proses mana? Dalam proses sewaktu cross examination. Siapa akan cross examine dia?
Prosecutor.
Public prosecutor. Get that? Okay, ini ada dalam the meaning of dalam section 54 subsection 2 tu. Ini elemen yang you all kena faham. Maknanya, ya.
Kalau accused person tu mungkin sebab emosi ke apa nak jawab juga. So macam mana? Is it relevant and admissible to the court?
Okay. Okay, kalau accused person, okay, bila ditanya maknanya dia tak relevant, tak admissible. Tapi kalau dia jawab juga, then what will happen that he will still be protected. Because whatever not relevant cannot become relevant simply because you ignore the law. Okay? You look at that one. So maknanya, ataupun you tengok kat elemen ni, failure to object will not make an irrelevant evidence relevant. Ya? So kalau court consider benda tu, okay, you mungkin respond, tapi the counsel must object. Dan kalau counsel tak object pun, counsel pun blur, tak object. Right? And court analyse it. It can be a ground of appeal. Get the picture? So kalau you buat sesuatu, mana benda yang tak relevant, tapi court consider, it can be a ground of appeal. That's why nanti akan ada, the learned trial judge make an error of law when he accepted the bad character evidence. Because law says cannot. Law says maknanya tak boleh, dia takkan boleh jadi boleh. Get the picture? Boleh? Kita memang ada ramai ilmu kan. Dan of course lah masa Zahid Hamidi tu kena cross examine dengan prosecution, kalau you tengok keadaan tu it was very heated. Kan dia memang cukup bengang dengan prosecution. Raja Rosella rasa saya, right? So she was a very good prosecutor. Lepas tu Zahid pun menaik kebengang kat dia sebab dia kena jawab. Sebab kawan tu pandai tanya soalan yang tak ada kena-mengena dengan protecting the accused person kan. So that is the proposition. Get the picture? Boleh? Boleh ya? Okay. So maksudnya, alright. So that will be section 54 subsection 2. Remember ada dua ya kat sini. The protection is at all stages. Protection against an accused person happens at all stage. This 154 subsection 2, the protection against an accused happens at the defense stage. Yeah? Defense stage saja. Understand? Get that? So nanti kita akan tengok kenapa ada benda ni berbeza. Okay? Now, okay, example of cases where the general rule is upheld will be this one. Ini adalah contoh-contoh cases where the general rule is given effect. Maknanya, you tak boleh tanya soalan berkenaan dengan dia punya bad character. Okay, this is an example. So maknanya as a general rule, bad character evidence cannot be brought. Kalau dibawa masuk objection, then the general rule apply. Get that? Now having said that, there will be situation where the shield can be broken. Now, dia adalah general rule, maknanya ada keadaan di mana bad character evidence boleh dibawa ke mahkamah. There can be situation where the general rule can be broken. Maknanya bila the shield is broken, maknanya you boleh bawa bad character evidence. That's what it meant. Ini maksud dia ya. Shield broken maknanya you boleh bawa bad character evidence. Contohnya, contohnya, you have Zahid Hamidi. He gives a lot of good character evidence. Then the shield can be broken. Bila shield broken, you boleh bawa bad character evidence. So katakanlah, there have been situation where Zahid Hamidi involved dalam assault. Ada beberapa lama dulu I ada baca dekat dalam surat khabar, someone actually file a report against Zahid Hamidi sebab dia tumbuk orang. Kita tahu betul ke tak?
Menantu.
Kan? Menantu dia tumbuk orang ke? Ke dia tumbuk orang? Ya. Katakanlah dia yang tumbuk orang lah ya. Katakanlah
dia tumbuk bakal menantu dia.
Oh, dia tumbuk. So maknanya dia lah. So kawan tu buat police report. Boleh tak I bawa benda tu kat court? Sebab it reflects bad character. Dia tumbuk orang. Right? So there can be situation where you want to bring in bad character evidence. So apakah keadaan yang you boleh bawa dia punya bad character? The first situation where you can bring bad character evidence, where you apply the proviso dalam section 51. 54 subsection 1. Tadi kita baca 54 subsection 1. In criminal proceedings, the fact that the accused person has a bad character is irrelevant. This one adalah the general rule. Get that? Ini adalah general rule dia. Warna ni pula. Tukar warna merah. This one. This one is actually the general rule which I mentioned dekat atas ini. Which I mentioned kat atas ini. So, ada kat bawah tu, unless evidence has been given that he has a good character. So, this will be a situation where the protection under 54 subsection 1 can be broken. Dia akan broken, the shield can be broken kalau you bawa good character evidence. Can happen. Now, bilakah defense bawa good character evidence? So, good character evidence ni boleh dibawa dekat prosecution stage oleh defense. We're talking about good character ni oleh defense. Defense boleh bawa good character evidence at the prosecution stage, dekat defense stage pun boleh. Now, bilakah defense bawa good character evidence dekat prosecution stage? Bila? Bilakah defense bawa good character evidence at the prosecution stage? Maksudnya prosecution stage siapa saksi you? Kita tengok sini, besar sikit kertas ya. So, bila cakap pasal bad character evidence, shield is broken. Adif. Shield is broken dekat, under section 54, subsection 1. The proviso, satu ialah at the prosecution stage. Macam mana shield can be broken at the prosecution stage? Bilakah defense boleh bawa good character evidence at the prosecution stage? Anyone have an idea? Sewaktu cross, you ada PW, you have PW who will undergo the examination in chief by the public prosecution, cross by the defense, re-examination by the public prosecutor. Masa cross, dia bawa good character evidence. Cakap apa? I put it to you that he is a good person. Contohnya, prosecution witness tu adalah dia punya PA. Right? PA ni satu hari dulu was in financial difficulties. Dia pinjam duit daripada accused person. Accused person beri pinjam RM500,000. He is now being charged for corruption. So what happened here is that at this stage, the prosecution is the defense is eliciting good character from the prosecution witness. Dia cuba dapatkan good character. Kalau ini berlaku, the shield is broken. Get that? At the defense stage, accused person voluntarily give good character evidence. Dia beri good character evidence. Macam Zahid Hamidi memang at the defense stage, dia memang bagi good character evidence. No doubt. So maknanya kat situ shield is broken. Get the picture? Boleh? Alright. So I rasa I stop dekat sini dulu. Nanti korang mengamuk kan lecturer seterusnya. Okay, next week bila I jumpa you all, kita sambung dekat section the situation where the shield is broken. Kita masuk dekat sini, okay? Alright. So, sekarang I nak download you all punya attendance list. Nanti saya nampaklah dia orang keluar masuk, okay ya? Alright. So, I think that will be all for today. InsyaAllah kita akan jumpa lagi minggu depan. Kita sambung dekat bad character evidence. Okay.
Okay, madam.
Thank you, Puan.
Thank you.
Alright.
Thank you, Puan.
Thank you, madam.